everyone. Welcome back to the Indian Patent Agent Examination Preparation video series by Pathways Consulting Solutions. Today we will look at session 7, that is Publication and Examination of Patent Part 2. Publication and Examination of Patent continued. In the previous session, we looked in detail about the publication of patent, the time limit for publication of patent, request for early publication. Then we also looked at examination of patent. What is the time limit for request for examination of patent? Who can request the examination of patent? We looked at what is anticipatory search that the examiner has to produce. What are the rules and responsibilities of an examiner in terms of preparing a search report? That is the first examination report, and what are a few powers of the controller with respect to post-dating, divisional application, and with respect to accepting and refusing of the amendments. Now continuing into those sessions, we will now look at the powers of controller in case of anticipation. Now in case if the examiner finds out any anticipatory documents as such referred in section 13 subsection 1 or subsection 2, then he may refuse the grant of the application, wherein if there is any prior art document that exactly discloses the applicant's invention under subsection 1 or 2 of section 13, he can refuse a grant of the patent unless the applicant shows that the priority date of his application, that is the date in which he first disclosed, is actually earlier than that of the document that the examiner has pulled out. Or 2, he amends his current patent application to such an effect that the controller is satisfied that the other document he pulled out is no longer an anticipatory prior art. Now according to subsection 2 of 18, now if the controller is of the opinion that under section 13(1)(b), that is there is another patent document which claims the same or substantially same invention as that of the present patent application, then the controller will ask the applicant to insert a reference of that other patent specification. Now if the patent applicant does not want to insert the reference, he has two options. One, he has to satisfy the controller that his application has a priority date earlier than that of the application or a patent that is pulled out by the patent examiner. Or 2, he has to amend to the satisfaction of the controller or the examiner, wherein the scope of the invention that is claimed in the prior art that is pulled by the examiner is no longer an anticipatory prior art. If he cannot do either of this, he has to insert a reference of that other application if it is classified under 13(1)(b). Now, according to subsection 3 of 18, as a result of any investigation under section 13 or otherwise, if there is another prior art patent, which claims the same invention that is claimed in the present application, and that particular invention, that particular prior art document has an earlier priority date, but however it is published after the filing date of the patent applicant. So even though it is earlier priority claim, but the inventor may not have the knowledge of it because the publication date is later than his priority date. In such case also subsection 2 will apply, wherein you have to insert a reference of the other published document in order for the grant of the patent. Section 19 talks about powers of controller in case of potential infringement. Now during the investigations, if the examiner and controller is of opinion that the grant of a patent by the applicant will lead to an infringement of yet another patent, so even though he grants the patent, even though it is novel and inventive and commercially applicable, but however the grant of this patent may at times leads to a infringement of another granted patent, then again the controller can ask the applicant to insert a reference. Now if he doesn't want to insert such a way of a reference, one, he has to show to the satisfaction of the controller that that other patent which the controller claims to be infringing or he infringes actually is not valid and there are reasonable grounds that it is an invalid patent. Or 2, the applicant has to amend his specification to the satisfaction of the controller. Now, in case if an applicant actually inserts a reference and he gets it granted, the reference will be deleted only after the other patent which the examiner considers to infringe or be infringed is revoked, or the specification of that other patent is amended by way of deletion of the subject matter of the application. So in short, in terms of potential infringement, if the controller is of the opinion that a grant of a patent may actually infringe another patent, he will ask to insert reference by way of public notice in the patent document. Now that can be removed only if the other patent is invalid or if that other patent is amended. Also, if that other patent in proceedings before the court or the controller said to be that relevant claims alone is invalid, which may be potentially causing an infringement suit. So in that case also the reference can be deleted. Now, Section 20 talks about the power of controller to make orders regarding substitution of applicants. Now, if the controller is satisfied by virtue of any assignment or agreement in writing by the applicant or at least one of the applicants for a patent, then he can direct that the application shall proceed in the name of the person to whom he has transferred his rights, the claimant or the names of the claimant, more than one or the other person, and that the application can proceed in his name. So if one of the applicants sells an application to another applicant, typically that happens in during mergers and acquisitions, in that case it has to be in writing or it has to be an assignment, then a notarized assignment document, then the power of a controller to allow the proceeding of that particular application in the other person's name. Now further in this section with regards to the substitution of applicants, if say there are more than one or two applicants and only one of them has granted the assignment right, then the controller cannot use his power to change or substitute until and unless he gets the consent from all other applicants. So it cannot be a decision of just one of the applicant, it has to be all of the applicants along with their consent. Further, there is also a strict rule with which the controller has to give this order. So the controller cannot give an order until and unless the assignment document or the agreement in writing has fulfilled certain conditions. It has to clearly identify the invention along with the application number or the patent grant number. Further, it also has to have the acknowledgement of all the persons involved, the applicants, inventors, etc. in writing that this particular assignment is related to this invention. Further, the rights of the claimant in respect of the invention has been fully established by the decision. And then after considering all of this, the controller gives direction for enabling the application to proceed for regulating in the manner in which it has to be proceeded. Subsection 4 of section 20 talks about a case where one or two or more of a joint application, any person that dies, then upon a request from the legal survivors or the legal heirs, the legal representatives of the deceased, the controller can direct to substitute the applicant or the change in applicant and proceed in the name of the survivor or survivors alone. Now, in case if there is any dispute that arises between the joint applicants in terms of substitution of the applicant, then the controller has to give an opportunity for the person who has a dispute, and the controller shall consider all the facts relevant to the case and take a decision based on the facts. Now, section 21 talks about time for putting an application in order for grant. That means in case if there is any time limit that is specified within the act or rules of this particular sections, then it has to be strictly followed. Any application that does not comply with the time limit shall be abandoned, shall be considered to be abandoned if they are prescribed by the Patent Act or by the patent rules. Typically, this time limit starts from the date on which any communication regarding an objection or compliance has been sent from the controller. So, date from which a notice of information is sent from the controller to the applicant, the time limit starts, and within the prescribed time limit, the compliance or a reply to the objection has to be submitted to the controller. Now, if at the expiration of that particular period, under two conditions, one, if there is an appeal in the High Court that is pending with respect to the application for the main invention, that is the invention per se. Now, in case if the application is pending, that is the main invention as such a subsection A, or a patent in addition of the main invention, then the time limit to be extended will be determined as prescribed by the High Court. Now, if the time within which the appeal mentioned under subsection 2 may be instituted has not expired, then the controller may extend the period as requested by the applicant. Now, in this subsection, it is to be noted that any request for extension of time under the powers of the controller should be filed before the expiry of that particular time limit. It cannot be filed after the expiry. Now further, if an appeal has been filed during that said further period, the court has granted an extension of time for complying with the requirements, then the controller shall also comply with the decision of the court. With this, we come to the end of the session on publication and examination of patents, along with a few powers of the controller regarding publication, examination and decision of patent applications. Now, if you have any questions or queries, please feel free to drop it in the comments. Please stay connected for further videos. Thank you.